Hello, everyone. Welcome to the Clarendon Law Lecture for 2022. I'm absolutely delighted that we've been able to restart this. I checked back at our records and it seemed like the last one was some time ago. So we can blame COVID for a significant amount of the gap, but it's marvelous that we have been able to restart it. The series has been running for many years with a lot of distinguished speakers taking the platform, including the likes of Lord Collins of Matesbury and Professor Harold Coe, Ernie Weinrib, Justice Stephen Breyer of the US Supreme Court, and Richard Posner. So the lecture series is the law faculty's premier lecture series, and we do it in conjunction with Oxford University Press. It's my job to introduce the introducer, but you will be glad to hear that there's only 2 levels. I was at a conference last week where there were 5 levels of introduction before you got to the actual speaker. I thought that was really quite record-breaking. So I am very pleased to be able to introduce to you Michael Beloff, KC, from Blackstone Chambers. He is a former president of Trinity College. He's been a member of the Court of Arbitration for Sport for 25 years, and he's arbitrated at 5 Summer Olympic Games. He's been the chairman of the Ethics Commission of 3 international sports, athletics, cricket, and skiing. He's the editor of the Sweet and Maxwell International Sports Law Review and the co-author of Sports Law. He's the leading independent leading independent legal directory, Chambers UK, describes Michael as a pioneer of sports law who is one of the most experienced and respected barristers in the UK. And he's been colloquially described as the godfather of sports law. So with that, I ask you to come and introduce our main speaker. Thank you.
Thank you, Mindy. It is a true privilege to be invited to introduce this year's Clarendon lecturer on the occasion of the first of his 3 lectures. I've been an admirer of Professor Weatherill for many years, and I've shared a platform with him at sports law conferences, at any rate when they were held in suitably agreeable locations. Professor Weatherill is best known to the academic community as the Emeritus holder of the prestigious Oxford Chair in European Law named after Jacques Delors, former President of the European Commission, and Margaret Thatcher's Bête Noire, a literally black beast for any non-francophones among you. Professor Weatherill has published numerous articles which have attracted more than 5,000 downloads. But while, of course, the law of the European Community remains an important subject, both for study and in practice, because of Brexit, it is less so in the latter aspect for English lawyers. But Professor Weatherill has always had a second string to his bow as a sports lawyer. That's an example of the precautionary principle in action. I note the synopsis of this series, and I quote, proclaims that the case law of the European Court of Justice offers a rich store of insights into just when sport is truly special. And I'd add that the insights are no less rich than when sport is not truly special. The Court of Justice at Luxembourg determined in the Mecca Medina case that sports anti-doping rules engaged considerations of European competition law. It involved, if I may remind you, or perhaps even inform you, 2 long-distance swimmers who claimed that the prohibited substance found in their urine samples was the result of an innocent ingestion of a Brazilian delicacy called sarapatel, concocted from boar's testicles, probably one of Matt Hancock's favourite dishes. As chair of the two panels of the Court of Arbitration for Sport, which initially considered the swimmer's defence, I can reveal to you that there was no evidence at all that either swimmer had actually ever eaten serapatel. So the case was the Euro equivalent of Donoghue and Stevenson, which created the modern law of negligence in tort on the assumption, as you'll all know, that the plaintiff had suffered an injury by consuming a snail in a ginger beer bottle, when it was never established there was a snail in the bottle at all. Now, Professor Wetherill proposes two intriguing questions in his lecture title. First, what is sports law? And second, do governing bodies in sport make law, or are they merely subject to it? Now, as to the first question, as the author of a book entitled Sports Law, whose next edition is in preparation, I hope that he will show definitively that the subject actually exists. And I shall profit particularly from Professor Wetherill's scholarship, taking care, of course, not to trespass too obviously across the line which divides research from plagiarism. As to the second question, it could not be more relevant or topical with the Football World Cup in Qatar being imminent. FIFA, next to the IOC, the most powerful sports governing body in the world, is responsible for the curious and allegedly corrupt choice of that venue more than a decade ago, and for its recent and controversial plea to both teams and fans to ignore issues of human and employees' rights in the Emirate and, and I quote, let football take the stage. One could not, I suggest, have a better case study for who is or who should be ultimately responsible for the governance of sport. A final word, if I may, before handing the floor to our distinguished lecturer. I hope that this lecture series is the harbinger of an interest by this ancient University of Oxford in sport, something of growing significance in the 21st century. Only 5 days ago, Matthew Syed wrote in a column in the Times that football is arguably the most important cultural institution in the world. I'm confident that Professor Weatherill will demonstrate this evening that sports law, whatever that phrase may actually mean, fully deserves serious academic attention. Professor Weatherill.
What are you doing next Monday? Week today. Some fantastic things going on in this law faculty. Introduction to Constitutional Law. Next Monday. Advanced Administrative Law Seminars. Next Monday. Human Rights at Work Seminars. Led by my friends and colleagues Anne Davis and Jeremias Adams Prassel. Next Monday. Also next Monday. Choices. Every 4 years, the World Cup rolls around. Usually, it disturbs our sitting and marking of examinations in the summer. This year, uniquely, it disturbs teaching in Michaelmas. Choices. Every football fan remembers his or her first World Cup. Mine was in 1970. I was 9 years old. I'd already been going along for a couple of years to watch my local club play at Boothbury Park, a ground that no longer exists. I love football, but when the World Cup appeared on my screen, I was entranced beyond measure. The colour, the excitement, the passion, the quality of football. Brazil won the first World Cup that I remember, led by the finest player of my lifetime, Pelé. You can see your life out in World Cups. I started as a 9-year-old. I was a spotty teenager by the time the next World Cup came around in 1974, which was lit up by the finest European footballer of my lifetime, Johan Cruyff. A although his Dutch team didn't win that World Cup, it was won by the hosts, West Germany. By 1978, I was sitting my A-levels. That was rather inconvenient because there was a World Cup in Argentina to watch. And the games, the important games, all took place early evening Argentinian time, which meant 11 o'clock at night, British time, which was awkward if you were trying to juggle watching the games with revising for an A-level in English literature. So it was Argentina against France or the Mayor of Casterbridge. Difficult choice. Always choices. It was another colourful, passionate, remarkable World Cup, which Argentina won. By 1982, another 4 years rolled by, and I'm a finalist in law at Cambridge University with the World Cup to watch. The timing was much more generous on this occasion. I was able to finish my finals, have a couple of days relaxing in Cambridge, and then get on a train to Spain to watch the World Cup. That's me, on a train to Spain to watch the World Cup. Looking pretty happy about it. Just 4 years ago. So for the first time, I got to see a World Cup match live. There's the ticket to prove it. In Malaga between Scotland and New Zealand. So it goes on. The World Cup's changed a lot. Back in 1982, you just rolled up to the stadium, bought a ticket, went through the turnstile and stood on the terraces. There's nothing like that nowadays. It won't be like that in Qatar next week. It wasn't like that in the first World Cup of the internet period held in Europe, which was the France World Cup of 1998. You had to buy your tickets in advance. You had to have your name or the provider of the ticket stamped upon it. So there's my ticket for the opening match of the 1998 World Cup in Paris between Brazil and Scotland. And you can see I've got that ticket from an approved source, the Scottish Football Association. Meanwhile, most tickets for that tournament were sold by the French organisers to French nationals and residents. So there was a discriminatory preference in selling in favour of French nationals and residents. So if you rolled up to the stadium, you would find lots of French people selling tickets at a significant markup, taking advantage of the discriminatory preference which had been put in place. So there's my ticket for Spain against Nigeria. On a very wet afternoon in Nantes, I bought it outside. And the original buyer of the ticket was somebody called Samson, whoever he or she was, a French national or a French resident for sure. Bit of law, you might have thought there would be a bit of law at some stage. Here's a bit of law. That's in breach of European Union law. What the French organisers did in that tournament was to discriminate on the basis of nationality in favour of French nationals and residents in a way that was unlawful. The European Commission took action after the fact and imposed a fine on the organisers of the French World Cup in 1998 and required that subsequently there should be no discrimination on the basis of nationality in the selling of tickets within the European Union. And that's exactly what happened. The next European World Cup was in 2006 in Germany. And there's my ticket for the game between Trinidad and Sweden in Dortmund, which, as you can see, was allocated explicitly to me, because I was, at the time, an EU national. Doesn't mean that there wasn't sport to be had outside of the stadiums for games that you didn't manage to acquire an official ticket for. There's my ticket for the game between USA and the Czech Republic in the charming town of Gelsenkirchen. I was, for these purposes, Hannah Kirchner. I really love the World Cup. I hope I've conveyed that. I'm still as excited by it as I was as a 9-year-old back in 1970. colour, the passion. Over 1 billion people are reckoned to have watched the final of the last World Cup. It's a big event. However, the World Cup has taken some troubling turns in recent times. The last World Cup in 2018 was hosted by Russia. That's the Russia which in 2014, 4 years earlier, had invaded and illegally occupied Crimea, Ukrainian territory. It didn't deter FIFA. There's the World Cup trophy on the left. There in the middle is Gianni Infantino, the president of FIFA, football's global governing body. And on the right is, well, you know who's on the right. President Putin, for it is he, awarded a medal to President Infantino for his services to Russia in bringing in the World Cup. Similarities, but no laughing matter. The next World Cup's no laughing matter either. It starts on Sunday, you know that. It's in Qatar, you know that. We are surrounded by the flood of information about corrupt practices, about failings in health and safety standards on the construction sites for the stadiums that will host this tournament, general failure to adhere to labour standards of an appropriate level for the migrant workers who've been building these stadiums, and more generally, absence of adherence to international human rights standards. World Cup's never been perfect. That 1978 World Cup, which interrupted my A-level revision, was held in Argentina, which suffered under a military dictatorship at the time. But things have got much worse, more glaringly so, lately. We can accuse those who are engaged in deciding where football tournaments shall be staged of corruption, but we can also accuse them of more systematic governance failings in transparency, equality, absence of it, absence of adequate representation and accountability. The question is, how do these really important decisions about where sports events shall be staged get taken? Who elects these guys? And they are almost all guys. That's what I'm interested in this week. Today, I'm talking about sports law, and I'm talking in particular about how effective sports governing bodies are at keeping rulemaking and dispute resolution in-house. Much of the practice of sports law is run from within the sporting family. That's today's topic. On Wednesday, I'm going to talk about circumstances, exceptional circumstances, in which sporting disputes spill over beyond the in-house resolution of disputes to the ordinary courts. In particular, on Wednesday, I'm going to be looking at the European Union's treatment of sporting practices. But the thematic concern of sports governing bodies is to claim a degree of autonomy from legal regulation so as to maximise their freedom to make their own choices about their own sport. Then on Thursday, under the title Making Sport Better, I'm going to argue that there's a need to crack open the autonomy of sports governing bodies, to subject decisions such as the allocation of the World Cup to much more stringent standards. So I'm arguing for ex-ante public regulation of sports governing bodies insofar as they operate within the European Union and beyond. What's sports law? Michael's already suggested this is an important question, and he's right. There are two forms of sports law. What I call internal sports law, on the one hand, and external sports law, on the other. Internal sports law is to describe the way in which things are done within sport. So it's a reference to the constitutions of the governing bodies of sport, which represent a transnational system of private ordering. Sports associations, sports federations in most legal systems are private associations. FIFA is a creature of Swiss law. Most sports are based according to a system of hierarchical self-governance. In short, a pyramid. It looks like this in football. Sport has been governed according to this pyramid structure for over 100 years in most cases. This is how sporting governance came into being, by creating a global authority with ultimate responsibility to set the rules of the game and to ensure their proper administration. In the case of football, that's FIFA. Below FIFA on the pyramid are the continental federations, which in Europe means UEFA, the body responsible for organisation of football in Europe. And below that are the national football associations around the world, of which there are 211. There's only 193 members of the United Nations, 211 members of FIFA. And these are the entities which are responsible for the governance of football. Clubs exist lower down the pyramid and have a voice only through their ability to persuade their national football associations to follow their interests. So it's a pyramid model, it's a top-down model where FIFA sets the rules and they percolate downwards through the continental associations to the national football associations, which then administer competitions according to FIFA's rules. We call it a lex sportiva. System of governance, system of rules, and a system of dispute resolution, which is based on an assumption that sporting disputes, sporting practice can be kept in-house and addressed internally. External sports law is simply to describe the law of states, the law of some international organisations, such as the European Union, as applied to sport. In principle, the law of states, the law of the European Union, applies to sport as it applies to any area of economic activity. So those are the two forms of sports law. Sports law describes internally what sports do, but the notion of external sports law recognises that sport is, in principle, subject to the legal rules of states and of international organisations like any other entity. Normative and descriptive questions about which legal order prevails: internal legal order, internal sports law, or external sports law. And let me say a few things about sporting autonomy. If you listen to governing bodies in sport, they will talk a lot about the virtues of autonomy. They will lay claim to the need to have autonomy from legal regulation in order to impose common rules on the sport which they administer. They will tell you that only sports bodies really understand how sports are run and should be run. And they will say that, therefore, legal supervision by states should be excluded. And they will add to that the claim that sport needs global rules so that the game means the same, whichever country it happens to be played in, and that therefore legal regulation by states should be excluded for fear that that would lead to fragmentation of the meaning of sport, jurisdiction by jurisdiction. So that's a case for autonomy from legal supervision, which you will commonly hear from sports governing bodies. And it's part of a much wider claim which sports governing bodies typically make, to have no business model. The slightly tongue-in-cheek title for these lectures was FIFA's business model is to deny that they have a business model. The idea is that FIFA is very keen to present itself as a socio-culturally sensitive organisation which doesn't get its hands grubby on money, but which rather exists only for the good of the game. It's a politically very savvy argument. It's one that has great political traction, and as a consequence, FIFA is very good at keeping political attention off it, at least until recently. So there's a case in favour of sporting autonomy, and you hear it loudly and regularly from sports governing bodies, but there are also cases against sporting autonomy. What's really going on behind this camouflage of the claim to sporting autonomy? Could it be that there's actually an attempt to maintain particular private interests at the expense of other private interests? Is sporting autonomy simply a way for the powerful to exert that power at the expense of weaker parties, most of all, obviously, players? We might also ask whether sporting autonomy is perilous to protection of the public interest. Sports governing bodies are global actors. They're really powerful. Shouldn't that lead us to be extremely nervous, indeed sceptical about the claim to autonomy, insofar as they may use that power in ways that are damaging to the public interest? And let's be clear, FIFA really does have a business model. It makes a huge amount of money, billions of dollars, out of the World Cup. It is extremely successful at what it does commercially. Let's have another look at that pyramid. FIFA stands at the top. Who takes the decisions in FIFA? Well, FIFA has a Congress at which each of the 211 national football associations is represented. And votes are taken in the Congress. One vote each for each national football association, irrespective of size. FIFA has a president, currently Gianni Infantino, again, voted on by the national football associations. FIFA also has a council, currently comprising 37 individuals, voted into power by the national football associations. So who awarded the World Cup to Qatar? FIFA awarded the World Cup to Qatar. Specifically, the Executive Committee of FIFA, which is the predecessor to the Council of FIFA, awarded the World Cup to Qatar. And the Executive Council of FIFA, which awarded the World Cup to Qatar, comprised 22 individuals, all men, mostly white, mostly old, mostly in some way contaminated by allegations of corruption. That's how decisions get taken. Crucially, the structural point here is that the only parties with voting power to determine the direction which FIFA takes are the national football associations. That's the electorate. So there's a top-down system, but it's also a closed system. Decisions about football are taken by football people. Clubs have no direct voice. They certainly have no vote. The bigger clubs tend in practice to be able to exert a degree of influence. Smaller clubs don't. Players, athletes have no voice, no vote. Fans have no voice, no vote. So what we have here is an extraordinary concentration of regulatory power at the top of the pyramid. And the anxiety here is that the appeal to autonomy as a virtue in sport is simply an appeal to the protection and promotion of the self-interest of those who are within the pyramid and have a voice. My next question is, well, how does the claim to autonomy, of which we should be sceptical, operate in practice? In practice, governing bodies in sport are really good at keeping dispute resolution within the family. And that's largely as a result of the commitment to arbitration, which characterises most sports governing systems in the world. Arbitration, of course, is a private dispute resolution system whereby parties commit to have their disputes resolved by specialist arbitrators, neutral third parties, which the parties prefer. prefer to use and choose to use rather than committing their disputes to courts, to litigation. So the whole point of arbitration is to keep disputes out of courts in the hands of private processes of arbitration. And as we are aware, in commercial practice, arbitration is very commonly used. Why? Why do parties choose arbitration over litigation? Well, it tends to be quicker. Arbitration tends to be quicker, cheaper than judicial process. Arbitrators can have expertise in the particular area in which they operate, which might not be felt or held by ordinary judges. And also, especially in a transnational context, arbitration holds out the promise of a consistent body of practice which will not be jurisdictionally fragmented by differences between national laws. Those are the advantages of arbitration generally. That's why it's commonly used in a great many areas. For sport, those advantages are particularly pertinent. Arbitration is speedy. That's really important in sport, where competition is short, where careers are short. Clubs, athletes cannot possibly commit to drawn-out litigation lasting years. Expertise is a particularly significant element when we consider sporting arbitration. Actually, most judges could probably find their way round commercial disputes, but they'd find it a lot more difficult to find their way round sporting disputes. So there's a really strong argument that sport should use arbitration in order to draw on those who have a real understanding of how sport operates. And then the third advantage of arbitration, which is the avoiding of jurisdictional fragmentation, is also particularly important in sport. Sport needs transnational rules, which are not different in meaning and effect depending on the state in which they happen to be applied. Arbitration can deliver that. So the key institution for the purposes of arbitration within sport, key institution for the purposes of dispute resolution is, as we've already heard from Michael, the CAS, the Court of Arbitration for Sport, which is not a court, it's an arbitral tribunal, which has significant responsibilities in football and across sport more generally. It's based in Switzerland, as almost all sports governing bodies are, and the centrality of CAS to dispute resolution in sport is written in to the governing statutes of many sports governing bodies. So if you go to the UEFA statutes, if you go to the FIFA statutes, if you go to the Olympic Charter of the International Olympic Committee, they all say the same thing about dispute resolution, which is that those involved in those sports must commit to resolve their disputes through arbitration, and they must commit not to bring disputes before judicial fora. And in practice, that's widely respected, in part because any athlete club that sought to break out of the arbitration commitments made under these statutes would find itself subject to sanctions imposed by sports governing bodies. But in any event, a court asked to consider a sporting dispute would normally enforce those obligations to pursue arbitration and would decline to hear the case. So the system is structured in such a way as to push dispute resolution into the hands of arbitrators, with the CAS at the top of the sporting apex. So, here's just an example. Milan Italian Football Club were found to have overspent in violation of the UEFA rules on financial fair play. That was subject to a decision of the adjudicatory chamber of the UEFA financial control body. They imposed a 2-year ban on Milan from European competition. The CAS reviewed that decision on appeal, considered it flawed and remitted it for reconsideration. On reconsideration, the adjudicatory chamber reimposed the 2-year ban, but gave Milan the opportunity to escape the ban by bringing their finances into compliance by a set date. Later on, UEFA and Milan agreed a consent award to bring to an end the investigation, and Milan, as part of that, accepted a one-year suspension from European competition in season 1920. The whole point is that goes nowhere near ordinary courts. That's dealt with entirely in-house through the dispute resolution procedures foreseen by UEFA, the adjudicatory body which investigates financial fair play, and then ultimately subject to review by the CAS. It's kept in-house. Sometimes CAS finds itself dealing with some really intriguing questions of contract law. The Emeritus case involved a player who had been the subject of a transfer from an Ecuadorian club to a Brazilian club. One of the terms of the contract between the two clubs, contract of sale, was that the Brazilian club would own 70% of the economic rights of the player, whereas the Ecuadorian selling club would retain 30% of the economic rights of the player. What that means is that if the player was subsequently sold by the Brazilian club, most likely to a European club, at a profit, then the Brazilian club would take 70% of the profit and the Ecuadorian club would take 30% of the profit. So the contract allocated the risk between the two clubs. The problem was that that was in breach of FIFA's regulations on transfers, which forbid third-party ownership of the economic rights of a player. So under FIFA's rules, the Ecuadorian club should have surrendered any economic interest in the player on the transfer. And the rationale for the FIFA rule was that if the two clubs both have an interest in the economic rights of the player, there is likely to be incentives to push for the transfer of the player, thereby destabilising contractual stability and team building. So FIFA bans the practices which the Ecuadorian and the Brazilian club have pursued. A fine was imposed on the clubs. They appealed it to CAS. And here's what CAS said. It's perfectly possible that said contractually agreed provisions are enforceable under a set of applicable civil law rules, and at the same time fall foul of the FIFA regulations, which in any case does not and cannot determine whether they are illegal, invalid, or unenforceable. So, FIFA imposes a financial penalty on the club for breach of FIFA's rules, but the contract law question about what happens to the allocation of risk agreed by the clubs under the contract is simply left to one side by the CAS. The CAS is saying, that's nothing to do with us. It's simply a matter of national contract law. That's a very strong statement of the separation of internal sports law from external sports law. What we're getting in the CAS increasingly is a form of hybrid law. The Bucharest against Bogdan Planic case concerns the suspension of a player's contract during COVID, a Serbian player playing in Romania. CAS concluded that the suspension of the player's contract was incompatible with the applicable rules, and it imposed an obligation on the Romanian club to compensate the player. How did it get there? It got there by mixing national contract law with FIFA's regulations on the transfer of players and FIFA's regulation on COVID. So there's a kind of hybrid law emerging through the decisions of the CAS, which rest on the lex sportiva, sometimes are forced by national rules. The practice of the CAS is extremely dense. FIFA has produced this commentary on the regulations on the status and transfer of players. So this contains the FIFA regulations which govern the transfer of players. It contains two relevant decisions of the dispute resolution chamber within FIFA and of the CAS on matters which arise under the transfer regulations. So this is a work which draws on both the existing rules and their practical application through the dispute resolution systems foreseen within the sport. It's 533 pages long. It's huge. And you find in CAS decisions recorded in this document a great deal of internal self-referencing. The CAS attempts to put together a more or less coherent system of rulemaking and dispute resolution. There are principles that emerge from CAS decisions: good faith, protection of legitimate expectations, the importance of proportionality. It's remarkably dense. So it's not state law, it's sports law. It's internal sports law in my terminology. It's not territorially defined, it's functionally defined. Governs sport. It resembles a conventional legal order. There are rules, there are decision makers, there's dispute resolution. So what's the relationship between the process of arbitration and the jurisdiction of ordinary courts? Otherwise put, what's the relationship between internal and external sports law? So we've got a CAS ruling. What is a CAS ruling when, if, it comes to be considered by a court in a state or in an international organisation? The key legal instrument is the New York Convention. The New York Convention on the Recognition of Enforcement of Foreign Arbitral Awards, which is a convention to which all important states that we would deal with in sport are party. The New York Convention is not concerned with sport in particular, it's concerned with arbitration generally. But it's of important application to sport. The point about the New York Convention is that all the parties to it commit to respecting arbitral finality. The New York Convention contains a strong bias in favour of the enforcement of arbitral awards rather than their reopening by national courts. So the New York Convention is heavily driven by the desire to protect the autonomy of parties' choices to commit to arbitration, not to undo arbitration, and thereby to encourage use of arbitration. So a CAS award is a Swiss arbitral award. It could be appealed to the Swiss Federal Tribunal, but the Swiss Federal Tribunal almost never overturns arbitral awards, and has done so extremely rarely in the case of CAS awards in sport. The assumption is that once an arbitral award has been concluded and is final in Switzerland, then it shall be enforced as such, usually without further inquiry, by the courts of any party to the of any state which is a party to the New York Convention. Usually, you don't have to worry about these sorts of things. Usually, CAS awards are respected and applied by the parties to them. Because if parties refuse to comply with CAS rulings, they would be subject to sporting sanctions imposed by the governing bodies of the sport. And most of the time, there is no need to proceed before ordinary courts of law to secure the enforcement of a CAS award. But just occasionally, it does happen. And the assumption of the New York Convention is that the attempt to escape the enforcement of the CAS award by recourse to a national court should fail. To make good that claim, I'd have to look at practice across 100 and more states of the world to show you that the New York Convention is taken seriously and arbitral finality is respected. I'm just going to give you one example. It's from the United States, and it concerns Gatlin, Justin Gatlin, who was a sprinter who was, on more than one occasion, found to have committed doping offences. He was suspended from the sport of athletics, appealed to the CAS against his suspension, but failed. The CAS confirmed his suspension from the sport, He was therefore subject to a Cass arbitral award, excluding him from the sport for a defined period of time. Gatlin didn't accept that, and he sought before courts in the United States, he was a US national, to resist the application of the Cass award. He sought to have the courts in the US set aside the Cass award, but he failed. Here's what the court said. Pursuant to the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the New York Convention, claims that have been properly submitted to arbitration and ruled upon by entities such as Cass are barred from relitigation in this forum. That's very strongly in favour of the finality of the arbitral decision, very much in favour of enforcing what Cass has decided. That was in fact only a district court in Florida. It's a relatively low-level decision, but it's absolutely typical of the way in which national courts approach their responsibilities under the New York Convention. They typically, routinely enforce arbitral awards. They do not question them. So finality in arbitration is an important principle. It's protected through the legal structures of the New York Convention and the practice of courts. There's a strong bias in favour of securing the enforcement of arbitral awards, and that is protective of the autonomy of the parties who have chosen to put the matter through arbitration rather than litigation. And yet, there may be reasons to consider that dispute resolution through arbitration has disadvantages alongside the multiple advantages. That's to say, should we really be quite so respectful of arbitral finality? There are two sets of issues that arise: private interests and public interests. There are two powerful criticisms of Cass. One is that it tends to privilege the powerful over the weak. The criticism is that it is not necessarily always the independent arbitral tribunal it should be, that sometimes it tends to mask power differentials and to perpetuate. Second line of inquiry, critical inquiry into Cass practice asks whether arbitration in sport is really consensual. The basis of arbitration is that the parties have chosen to commit their disputes to arbitration. But in sport, the commitment to arbitration is written into the statutes, the constitutions of governing bodies. Athletes really don't have a choice about whether to commit to arbitration rather than litigation if they want to be athletes. So there are questions about whether Cass awards should be granted quite the respect they appear to be given. These issues have been raised and discussed by both the European Court of Human Rights in Strasbourg and the Bundesverfassungsgericht, the German Federal Constitutional Court, in cases involving alleged doping offences where the individuals have been subject to penalties imposed by governing bodies and suspended from the sport in circumstances where Cass has protected the decision of the governing body. And the applicants, particularly Pechstein, who was a skater, German skater, the applicants did not simply accept the conclusions of the Cass, but instead embarked on lengthy litigation before the Court of Human Rights and before the German courts to challenge the decisions taken by Cass under an allegation that the Cass decisions were not those of a genuine arbitral tribunal, but rather those of a partial and flawed tribunal. In both these decisions, the courts gave a conditional green light to the Cass. In both decisions, Court of Human Rights and the Bundesverfassungsgericht said there was no objection in principle to arbitration as a means of private dispute resolution. Quite so. But they both insisted there were certain minimum standards of procedural justice that had to be met before the arbitral tribunals. And in the absence of those minimum standards of justice, then the arbitral award handed down by CAS would not be respected, would not be treated with the process and respect that the New York Convention dictates. In both cases, the courts were persuaded that the CAS was a genuine arbitral tribunal, subject only to requiring that it offer a more intense approach to public hearings. And the CAS has indeed reformed its practice accordingly so as to provide public hearings to a far greater degree than it did do previously. These are important decisions. They uphold CAS as a genuine arbitral tribunal, whose decisions should be respected in the way that the New York Convention expects. But CAS is also here put on notice. What these decisions are saying is that so long as CAS maintains the standards of procedural justice which are required by the Convention and by German constitutional law, then the CAS decisions will be respected. But if CAS falls short of those standards, then it can expect to lose its influence within the legal orders of the states which are party to the Convention and in Germany. So there's a dynamic process here whereby CAS's practice is subject to a kind of ongoing review by national courts to ensure that it really does constitute a genuine arbitral tribunal. As far as the public interest is concerned, there would be a clear concern were arbitral finality to prevail over any notion of public policy. That's to say, there would be genuine anxiety were it the case that arbitral finality could set aside concern to undermine public interests. And the New York Convention recognizes that tension. Under the New York Convention, there is a public policy exception which permits national courts to withhold respect for arbitral rulings insofar as those arbitral rulings violate public policy. So this is an exception to the assumption of arbitral finality under the New York Convention. It's an exception to the assumption of a pro-enforcement bias under the New York Convention. Public policy is, as an exception, to be interpreted narrowly in this sense. We're back to Gatlin, the doped sprinter, and this is the decision of the District Court in Florida. Claims that have been properly submitted to arbitration and ruled upon by entities such as CAS are barred from relitigation in this forum. The only conceivable exception is where enforcement of the award would be contrary to public policy. This, however, is a very slender exception, reserved for decisions which violate the most basic notions of morality and justice. And in this case, the Gatlin case, Florida court expressly said that it found the reasoning of the CAS in confirming his suspension to be capricious, but they did not regard that as a sufficiently serious flaw to refuse to enforce the CAS ruling. Quite the reverse, they enforced the CAS ruling. Capricious reasoning does not meet the standard of public policy, which the New York Convention recognizes as being a reason to withhold the enforceability of arbitral awards. So public policy is recognized as a reason to set aside arbitral finality, but it is extremely rare. But the very existence of the public policy exception under the New York Convention acts as a window between internal sports law and external sports law. It means that sometimes, where public policy is truly engaged, internal sports law may not claim autonomy, but instead, external sports law, state law, EU law, will step in and subject sporting practices to supervision in the name of the protection of public policy. What I'm going to do on Wednesday is look specifically at how the European Union deals with that tension between the virtues of arbitral finality and sporting autonomy on the one hand, and the importance of promoting public policy on the other. Now that's where I'll stop for tonight. Thank you.
Well, ladies and gentlemen, Mindy, the chair of the faculty, is suffering from jet lag, entirely entitled to do so because she's just flown back from Singapore. So it falls to me not only to introduce Professor Wetherill, but to propose the vote of thanks to him. So in my beginning, as it were, is my end. Now, predictably, Stephen gripped our attention from the very start with his reminiscences as to how he prioritised his love of football over his studies. And it sparked actually a personal memory. My favourite sport is athletics. And when I was a pupil barrister trying to win a tenancy, the 1968 Olympics were held in Mexico City. Live coverage on television started after midnight and continued until dawn. And like Stephen, I fear I put pleasure before career development, but then I was a good deal younger then. Now, after that powerful introduction, he then developed his subject with characteristic clarity and learning. A judge in a criminal trial often says to the jury, "I won't repeat counsel submissions which you've all heard so recently." And that is true, of course, of Stephen's talk tonight, as far as this particular audience is concerned. So need I say more, other than to thank him, than to say that he has whet our appetite for the next 2 lectures in this series, and he's also actually whet a desire for drinks, which I hope I'm right in saying, are served in the foyer. Stephen, thanks very much indeed, and we look forward to the conclusion of the series. Thank you.